Good afternoon, everybody. Welcome back to another session, all things employment law related. So get your questions in down below. As you know, my name is Chris Justice. I'm a lawyer with Samfiru, Tumarkin, working out of the Toronto office. And as I say, now is the chance to get your questions in live. So if you've got anything to do with the workplace, maybe a contract you've got some questions about, maybe you're going through something during the working relationship itself that you've got a question about, or possibly you've been let go, maybe given a severance package, and you're trying to figure out perhaps if that's fair and reasonable. But whatever it is, get your questions in and I'll do my best to answer them as always for the time allotted for today. But before I get into some questions, I just want to talk about a couple things off the top, some stories that have come out in the news, some things I've noticed in my practice recently. The first thing I wanted to talk about had to do with the BC Human Rights Tribunal actually awarded an executive assistant a bunch of money after there were findings made of harassment, abuse within the workplace. And so this sort of story or this news brought up the issue of how human rights and how discrimination or harassment claims are handled or should be handled within the workplace, and what you should do if you're in a situation like that. And so every place, for the most part, is going to have an anti-harassment policy. Every place, for the most part, is going to have some sort of anti-discrimination policy. There are obligations under law for employers to ensure that their workplaces are safe, free of harassment, free of discrimination, all those sorts of things. So there should be a policy in place. And if you're somebody who has perhaps experienced abuse or harassment within the workplace, maybe the workplace has become toxic for some other reason, what you generally want to do is make your voice heard, raise your complaint, raise your objection or concern, and put that in writing. And usually, again, there should be some process through the anti-harassment policy or anti-discrimination policy as far as how to advance those complaints. You know, whether you have to direct the complaint to HR, whether you have to direct the complaint to somebody else. But typically you want to follow those processes so that the company can't later on say that you didn't follow those processes, or so that the company later on can say that they didn't know about the particular concern or issue that you were facing. By filing a complaint more formally through their process, that sort of achieves both of those two things at the same time. So that's the reason why you should be doing that, and just, you know, to create a record in general. But you also want to make sure that in your complaint, you can provide some information as well, some specificity to it. So, for instance, if you know there were instances of harassment or discrimination that you suffered from, you want to make sure you understand what the definition of those things are, and then just connect them to specific instances that happen in the workplace. Whether you've got maybe something in writing that can help support your position. Maybe you've got some witnesses that would be able to support or back up what it is you're saying in the case that it's a he said, she said. But you want to try to provide some specificity rather than making more generic statements, so that the company has more information to work from. And if anything, that'll put even more pressure on the company to investigate and look into things and make sure it's all fixed or rectified going forward. Sometimes when there's little information given, again, that could possibly give the company out when it comes to the investigation side of things. But if you've given them everything you know and enough information, then they're absolutely going to be obligated to start an investigation and look into it. And if during the investigation you find that the company maybe dropped the ball, or they haven't done a full, thorough investigation, maybe they're doing it in a biased manner, that's all going to come falling down on the company if that's to be found to be the fact of the matter. And that's another reason why at least you want to start the process, do what you need to do, file your complaint, and then the ball goes into the company's court as far as how they handle it. If they handle it great and they rectify the issue, then that's great. And hopefully moving forward, that stuff doesn't happen again. But there are a lot of situations where, unfortunately, these investigations are not carried out as well as they should be. And then surprisingly, the outcome gets told to the complainant, and there's no justice, there's no vindication in terms of the concerns they raised, and that can become a problem. And that may actually allow you as the employee to essentially leave the workplace based on the company's failure to adequately investigate, based on the company's failure to, make sure that things are fixed going forward. Because then they could be seen as condoning that sort of behavior if they do something wrong on their end. But it all starts with making a record, making sure your concerns are documented, going through the policy of the companies, and then hoping that you get the outcome that you want. But if not, at least you've then got some options moving forward if you simply can't work in that environment anymore. And I think that far too often people do go through legitimate issues within the workplace, but then they leave the workplace before those issues are investigated or before those concerns are brought in a more formal fashion. Sometimes people may have a chat with their boss or someone, a coworker or a colleague of theirs about issues within the workplace, but not maybe HR or someone higher up that's supposed to be looking into that information. And as I say before, you just potentially give the employer an out where they might say that they were ignorant to what's going on, or that sort of thing. So definitely, if you're in a situation like that, human rights concerns, harassment, toxic work environment, you want to file the complaint. Depending on how the company responds, you may or may not have a couple options as far as possible severance is concerned, or not. But that's what I wanted to kind of touch on, at least on the outset, when it comes to harassment, discrimination related claims. Another thing I wanted to talk about is just more of similar things that I've been talking about of late, as far as trends in the news in terms of a lot of layoffs going on. A lot of terminations are happening across various different sectors. There are large groups of employees being let go. A lot of times it's due to restructuring, reorganization, whatnot, maybe something to do with the economy. But if you're someone who's been let go, frankly, whether it's in a group of a lot of people or not, you want to make sure you get legal advice before signing any severance package, before agreeing to any specific amount of severance or talking specific numbers with your employer. You want to get some legal advice first, because whatever you may say before you get in touch with a lawyer could actually hurt you or not necessarily help you as much as if you maybe didn't say it or said something different. But in general, you want to make sure you get legal advice before signing any severance package. Most of the time, whatever the company's offering you from the get-go is not going to be anywhere close to what you're entitled to. And that's just more reason why you need to get that legal advice. And in fact, in cases where you're let go amongst a large group of people, and perhaps where there's a bit of a downturn in the industry itself, you may actually be entitled to more severance than if the economy was doing a lot better. So with all these layoffs and terminations in certain industries, it definitely seems like there are not a lot of positions available, even if you lose your job and try to find another, which, as I say, can affect how much severance you get, and actually, in some cases, bump up the severance that you otherwise would be entitled to. So, as I say, get some legal advice before signing off, because you may be throwing away thousands or tens of thousands of dollars or more potentially. I'll get into some other things I wanted to talk about off the top if I've got time, but I'll just get into some of the questions that have come in today. So I've got one from Sunny on YouTube, who's saying that they've run out of EI benefits, but their doctor is saying that they need more time off for medical reasons. And they're wondering if they can keep their job by staying on that medical leave of absence for a longer period of time. And then they also are asking whether there's a limit as far as how long an employee can be off work before the company can terminate them or do something, I guess, in that capacity. So there's no set limit to how long someone can be off work. In some cases, there have been situations where people have been off work for 2, 3, 4, 5 years, and the obligation is still on the company to make sure that they have a job in place upon the return. And then there's been other cases where maybe someone is only gone for a year or two, but their doctor is saying that there is zero prospect of any improvement any longer for the rest of this person's life. And so in a situation where the prognosis of recovery is really, really poor or just non-existent, that could allow an employer to let you go sooner. It sort of comes down to how long you've been off combined with, what the prognosis is going forward. So as I said before, there are some situations where someone's been off work for 4 years And, that's relatively speaking a long time. A lot of employers are going to sort of keep someone around for that long. But at the 4-year mark, that person's doctor was saying that they could potentially come back, say, within the next year. And in that case, the court said that because there was a hope of the employee coming back in the relatively near future, even though 4 years had already passed, there was still the onus on the employer to keep that job available. But it will come down to a case-by-case basis. But I think that if you are getting pressure from your employer to go back to work, or if you get the sense that your employer is getting really frustrated or annoyed at how long you've been off work, and you're worried about maybe being let go or worried about some other issue, you definitely want to give us a call first. You want to get some advice, because unfortunately, a lot of times employers don't want to wait around that long, or even long at all. And they, in a lot of cases, do let people go, or they try to argue that they can't accommodate that person any longer because it's getting too costly for them. But in the vast majority of these cases, the employer hasn't, incurred a cost that's high enough where the law would say that they're allowed to basically let you go. So a lot of employers sort of jump the gun. They cut ties with employees that are off on disability leave too soon. They don't wait long enough. They're not patient enough. And that's when they can get into some hot water, because not only will they have to generally pay the person severance, their full severance, which could be as much as 2 years, but they're also potentially now on the hook for discrimination for failing to accommodate. So discrimination on the basis of a disability. If you had never been on a disability leave, this wouldn't have happened. Well, if that's the case, then that usually points to discrimination. Whether you're getting EI payments or not, the same logic still applies as far as what your employer is obligated to do, and as far as, just accommodation in general. But if you've got any other questions, Sonny, I definitely recommend you give us a call and we can kind of talk about it a bit more. Hopefully there'll be a return for you in the not too distant future. But thanks again for your question. I've got another one in from BB Smooth on YouTube, who is asking, if an employer decides to no longer pay travel expenses or mileage, what would be a reasonable amount for you to be out of pocket for this? So that would depend on your particular situation. So for instance, if an employer decides to no longer pay travel expense or mileage, and let's say that on average you're spending, $500 a month on traveling or mileage, then you may suggest that a $500 cash payment, so to speak, could be acceptable in lieu of them, paying for these expenses. So I'd probably try to get a sense of what your actual expenses are on average. And if your employer is removing this particular policy of its, perhaps there's a compromise where, you can get reimbursed. And hopefully you can get reimbursed to the extent that you're not out of pocket any money. If the employer refuses to pay you anything out of pocket, or sort of refuses to replace the removal of this policy with some new policy, and now you're just having to straight up pay for your own travel expenses and mileage, then depending on how much you're actually spending, say in a given month or year, that could definitely be seen by the courts in Ontario as being unreasonable, that your employer has made a significant change to the terms of your employment by virtue of taking away this expense reimbursement, and that this is costing you a significant amount of money more. And you could argue that that's not what you signed up for, and sort of try and insist on the employer to go back to how things were, or to compensate you either way. But if the financial hit you're taking as a result of this policy being taken away is not as significant, then there are, still some situations where employers can make changes that aren't as big, even if it is somewhat of a negative change, and it may not mean you have much of an option. A quick example on that would just be if, for instance, your employer paid you, $500 every year for benefits. Say you're making $100,000 a year, and they remove that $500 benefit payment starting in 2024. Well, clearly your employment, in terms of your employment, have changed, right? You're not getting that $500 payment, but in the context of the overall picture about how much money you're making every year, $500 is not likely going to be seen as that big of a change. And so it's possible that the employer could get away with that. But on the other hand, if you're taking a hit financially of 20% of your salary, or you're having to pay an extra 20% out of pocket that you didn't pay for before, then that might very well easily make up a significant change. And then you'd have more leverage to kind of push back. But definitely before sort of quitting or getting into too much back and forth with the employer over this issue, you want to give us a shout just so that, you know, you're not saying or doing something that might hurt you later on. I know a lot of people will have disagreements with their employer about certain terms of their employment and things changing, and then tell the employer something like, you know, if this doesn't change by tomorrow, I'm quitting. And then they'll come and see me after they've quit their job. And, you know, a lot of times, unfortunately, I'm telling them that they may not have a great legal case and now they've left their job. So it's just another reason why you want to, before quitting due to any constructive dismissal or before maybe being pushed to quit or pushed to resign, have a call with a lawyer, get some legal advice just before you do that. But thanks for the question. It's a good one just in general when it comes to changes being made. Got another one in from Brennan on YouTube, who's asking, or saying rather, that their employer owes them almost $9,000 in unpaid wages. Brennan is saying that they've been recently laid off, and when they ask their employer about the money, which I take to mean the wages owed, the employer doesn't respond, not sure what to do. So number one, Brennan, it seems like if you've been laid off, assuming it's, well, even if it is a temporary layoff or not, it looks like you're probably owed severance just for the fact that you were laid off. But the second issue is about wages that you were owed as of your day of layoff. So that's a second issue, separate issue. And just like I'd probably be pushing for your full severance if I were you, you definitely want to make sure you get compensated for the work that you've actually put in, you know, because that's even less contentious than severance. It's stuff you've already done that you haven't been compensated for. And it's a good amount of money. $9,000 is no small chunk of change. So I think that it would probably be beneficial if you give us a call. We could set up a consultation to address both the issue of whether you're owed severance as well as the issue of the unpaid wages. Seems like you've tried your hand at it and they're just not responding. So it may be that you'll have to take a lawyer's letter on, you know, a law firm letterhead to get a response. God forbid, maybe it takes you having to sue them, but I would start off by calling our office. Maybe we can try to resolve it in the early stages. But if not, you may have a very valid claim against them for those wages. And the only other thing I'll say is that it'll go a long way if you've got evidence about the unpaid wages. And this is just a general point, you know, any documents that you have or that anyone has when it comes to an agreement between two people that was broken later on, those documents are going to be really handy. If you've got, like I say, some sort of proof of days or hours you've worked or put in that you haven't been compensated for, maybe some emails from your employer that say that they are going to pay you and they've just reneged on their promises. But think about things as well from an evidence standpoint, as far as how you're going to prove that you're owed the wages. Because assume, I guess, initially that the company's going to deny that they owe you any money in a lot of cases, or deny that they owe you severance or whatever it is. You're going to get pushback in general from employers. So you want to kind of think, how do I prove this? How do I convince them that, you know, they're not going to stand a chance if this goes forward, kind of thing. But I'd say in any case, give us a call, Brennan, and we can talk about it a bit further. Thank you for your question, though. I've got another one in from James on YouTube, who's saying that they work as a security supervisor and that after 15 years, the site that they were supervising is shutting down. And they were told that at the end of April, so a little less than 2 months from now, they're no longer going to have a job, but they haven't been offered any severance, and they're asking if they are owed a severance. So yes, James, it's highly likely that you are owed severance, and a lot more than just the notice that you've been given. Sometimes employers will notify people ahead of time that their employment is coming to an end, and they'll give them what's called working notice. And in the eyes of the law, working notice is seen in a very similar way as, you know, when an employer pays somebody out their severance. So if, for example, your employer gives you a month of notice ahead of time, and then on top of that offers you another month of severance, then the law is typically going to look at that as though you were offered a 2-month package. So it seems, as I say, that James has been given some working notice until the end of April, but that's only about 7 weeks, maybe 6, 7 weeks. And being there for 15 years would mean that James could get, for all I know, something like 20 months. So clearly, just accepting 6 or 7 weeks of working notice after that many years put in, even when the company is shutting down, is not enough. The only thing that could possibly limit, I think, your rights in that sense is if they're shutting down from a bankruptcy perspective. If a company is going bankrupt and they've filed for, well, not Chapter 11, but they filed for creditor protection in Canada, that might be a different scenario. But if they're just shutting down and they haven't made that filing, then, just because they're shutting down doesn't mean that they're not obligated to pay you way more or offer you more severance than they have. And as I say, you could get a month for every year you've been there, if not more. So I think all the more reason to give us a call and have us look at your situation so we can fully tell you kind of what to expect. But thanks for the question. I've got another one, it's a follow-up from BB Smooth earlier, just saying that they work in a sales environment, they travel a lot, and this just again had to do with their employer no longer paying their travel expenses. So yeah, BB Smooth, it's, you're saying you need to do some calculations, figure out the percentage you would have to pay. I'd say do that for sure. It's always good to kind of break down, what is the financial hit I'm taking as a result of, whatever the company's doing. In your case, it might relate to mileage. Somebody else's case, maybe they get a bonus taken away from them and they got to calculate, okay, if this wasn't taken away, what was I looking at? So this kind of stuff is always helpful because if you can put, of course, a dollar amount on it and you need to negotiate something in terms of getting a lawyer involved, coming forward with that information, with those calculations, going to go a lot longer than, or go a long way than just sort of saying that there was a hit taken. So I'd say do that first, but still consider giving us a shout if the number is quite significant. I've got an email or a question from Vivek on YouTube who's asking about, harassment that includes harassment of a sexual nature that the HR tries to protect the culprits. They want all the information and then they fire. So earlier on in this session, I was talking about, for those just joining, the fact that companies need to have anti-harassment policies in place under law. They need to make sure that, work environments are free from harassment. And of course, that includes sexual harassment as well. If you are somebody who's been subjected to sexual harassment within the workplace, absolutely a very serious issue, something that needs to be brought to HR if that's the first point of contact. Vivek, you're saying that the HR that I guess is looking into the complaint is trying to protect those who were the culprits, which unfortunately can happen. So it'll just come down to how exactly they're trying to protect the culprits, because of course, if there is evidence of that, or there's evidence of the companies trying to brush everything under the rug, or maybe gather a bunch of information from you and then kind of work backwards and conduct a bias investigation, then that's, as I said before today, a huge issue. And not only does that then involve someone getting their full severance in a lot of cases, but also damages for human rights violations, damages for failing to adequately investigate the concern. So there's a whole can of worms that can be opened up if it's found that the company is trying to protect certain people. But Vivek, again, it'll come down in a lot of ways to the evidence that you have in support of the fact or the idea that they're protecting the culprits. What exactly are they doing? Is there anything in writing? Could be email, could be text messages, or anything that can support the complaint of sexual harassment. Are there witnesses as well? Is it possible to get somebody to provide a statement, just saying that I witnessed or I heard this happen? So think again of it from an evidentiary standpoint in terms of how to prove it, because naturally, whether you like it or not, a lot of companies are going to try to justify their decisions. And a lot of times they're going to try to deny things outright from even happening, or whatever the case may be. So you want to think ahead, think about, what could come, what could I anticipate them trying to say to save themselves, and thinking about kind of getting in front of that as far as, like I say, evidence or documents or anything like that. I've got another question in from Keno on YouTube, who's asking whether they can record a meeting with their boss without letting them know, and whether or not it's legal. I think this is a good question. I know I speak to a lot of people who either have recordings on them already and they're wondering if they can use them, or they're thinking about making recordings. So generally speaking, if you are in a room or anywhere for that matter, and you are an actual participant of the discussion or the meeting or whatever is being held, you can record that meeting without them knowing. And that's not a problem from a legal standpoint. Now, if you record a conversation that you're not a part of, like say you're around the corner and you're recording something that's this conversation is happening just behind the corner of the wall, if they don't know, then that could actually be a criminal issue. So you want to be at least a participant in the conversation. And if, as long as that's true, you don't need to let the other person know. Now, if the company finds out you're recording them, let's say you're part of the conversation, you're recording them, you don't tell them, there's nothing criminal going on there. But your employer later on finds out, it's possible they could be mad. It's possible they could let you go. There are situations where people are let go because they've been caught recording things. And that's not necessarily a wrongful dismissal in the sense of the reasoning not being good. It still means that they're generally owed severance. So it's not to say that they can let you go because you made a recording and then screw you over as far as severance is concerned. But it could, practically speaking, happen where they come to you and they say, we don't want people recording people and we're going to let you go. So there is a bit of a risk there. But as far as that as being to the level of just cause or criminal or anything like that, no, you can record. And if, maybe later on there's a need for that recording, you can use it in a court potentially, or in sort of the litigation stream. So it could definitely be useful, especially if later on you maybe catch them in a lie. It's just, you got to, just take into account whether they find out, if that's something they're going to be happy about, and then potential ramifications after that. But it can also have its benefits, as I say. But having said that, that's going to actually be my time for today, everyone. I do have to go. I appreciate everyone tuning in as always. I'll definitely be back to answer more of your questions, which we'll let you know about in the near future. We do have other sessions with other lawyers, though. You see down below there. Jeremy himself will be doing another session on Thursday this week. So if you've got any questions about employment law stuff, definitely tune in at that point. Otherwise, I'm sure I'll see a lot of you again. Do take care and enjoy the rest of your day. Thanks very much. Bye for now.